Competition Appeal in the matter of competition market for Allergan Plc.
Yes, Mr. Turner, good afternoon.
Good afternoon, members of the court. Our plan in the limited time that we have left this afternoon is this. Professor Bailey will respond straight away on the issue of continuation of the pay for delay agreement, in particular after Mr. Patel exited. I'll then cover 3 points in response to Mr. Brearley in particular, and I'll wrap up. That ought to leave about 45 minutes, we estimate, for the companies before your 4:30 p.m. hard stop.
Okay, good. Yes, Mr. Bailey.
May it please the court. I'm going to address issue 6. That is whether the tribunal erred in finding that the 10 milligram agreement continued after the 29th of May 2015, turned to be the 1st of September 2015. I'm going to organise my submissions in 3 parts. First, to summarise the CMA's case on duration, as it is set out in the decision and was put at trial and is maintained in these appeals. Second, to respond to 4 main arguments advanced by Auden and Allergan. Just to identify them, they are, first, the human actor point, whether the common understanding evaporated when Mr. Patel left Auden. Second, the tribunal's finding in H2 that no acquirer of Auden knew or should have known about the infringing agreement. 3, Allergan's claim that it knew nothing about any wrongdoing. And 4th, the transfer of the hydrocortisone business to Actavis UK Limited on the 1st of September. The 3rd part will address the CAT's own reasoning in H2, and that was related to the Actavis Auden undertaking being an economic unit fixed with knowledge of the infringing agreement. May I start with the CMA's case? As your lordships are aware, we set out in our responsive skeleton, core tab 9, page 294, the 4 core elements of our case. And just to identify those in headline terms, they are, first, the parties' conduct was exactly the same after the Allergan takeover in May 2015 as it was before. Second, the managing director of Actavis UK, Mr. Jonathan Wilson, was interviewed by the CMA. He told the CMA that he understood that Actavis was supplying AMCO as an alternative to AMCO entering independently and competing on the merits. Third,
Have you got a reference for that?
I apologise, my lord.
Have you got a reference for that?
I'm going to give you references to Mr.
Okay.
Wilson's transcript, yes, my lord. It is to be found in the supplementary bundle, volume 6, tab 28, starts at page 2426, and I'm going to take the court to a couple of relevant passages, if I may, in just a moment. The 3rd point is that Actavis used the same terms of supply it had with AMCO to try and buy off another competitor that had actually entered the market in late 2015, that's Alyssa. And 4th and finally, as my learned friend Mr. Turner said in opening, we say that the impression given to the other undertaking, here to AMCO, was that the common understanding continued. Now, if I take each of those in turn, yesterday Ms. Ford showed you the passages in the decision where the CMA found that there was a continuing course of dealings. Just for your note, that's paragraphs 6.760 to 6.762 in the core bundle, tab 11, page 1126. Can I just add 3 points, please? First, it's important to bear in mind that when addressing this issue, the common understanding had been in place for 19 months before Allergan buys Auden. Just to put some financials on this, by March 2015, a couple of months before the takeover, the market price had reached £55. And so that meant that the value transfer on 12,000 packs a month was a cool £640,000 pure profit every month.
Sorry, 640.
640. And my lord, in case one wants a reference for what I've just said, that's a decision, paragraph 6.392, subparagraph B, which is to be found in the core bundle, tab 11, page 1025. So that's in terms of the financials. But the second point is about the commercial context in which this conduct took place. And on this, helpfully, the tribunal in H2 describes, by reference to the contemporaneous documents of Octavis, what that context was. And I would like to show the court, very briefly, a passage from that, if I may. It's paragraphs 128 to 131 of H2, to be found in the core bundle, tab 10B, at page 466. And I recall the Master of the Rolls saying one's not too keen on multiple subparagraphs and bullet points. So if I may, what I'd like to do is just show the court and cut to the chase and go to paragraph 131 at page 471. And this is where the tribunal is drawing the threads together, and it's really the last sentence I'd like to focus on. The incumbent, Auden, would have appreciated the importance of keeping other holders of marketing authorisations for hydrocortisone, even if only skinny label, out of the market. So in other words, there's a clear appreciation of the competitive threat. That's the context in which this continued course of dealing occurred. And then my third point is this. As Lord Justice Green asked on day one, when a court wishes to draw an inference, one asks, well, is this conduct commercially logical? The tribunal itself asked something similar in paragraph 43 of H2, core 10b, page 45. My submission is, well, self-evidently, the heavily discounted supply makes no economic or commercial sense at all, but for AMCO staying off the market. As my Lord the Master of the Rolls observed on day two, you don't need to be a competition lawyer to recognise that this does look a bit fishy. But there is more to the CMA's case. And I'd like to show the court next the second element, which is the interview with Mr. Jonathan Wilson, the Managing Director of Octavis UK, who was asked about the arrangements and the understanding during the investigation. And that is to be found, as I've already indicated, at the Supplementary Bundle, Volume 6, tab 28, and in my bundle it's at page 2426. And this is very important because, of course, this is where the CMA went and obtained evidence from a key protagonist. But as I'll come on to develop, this witness was not called to give evidence before the tribunal. Now, after the necessary caution is given, can I ask the court please to go to page 2441, that's internal page 16.
Sorry, which tab is it?
It's tab 28, my lord, and it should say at the beginning, transcripts of an interview held on 22nd July 2019.
It's tab 27.
I do apologise.
Yeah, and what?
And it's
what
internal page 16, my lord.
16, which is 2428.
I'm grateful. And what we see here at line 18 is that the CMA interviewer is expressly asking Mr. Wilson, what was your understanding of the terms of that supply agreement? And his answer, you can see at line 22, well, at the time, clearly, we're aware of the supply arrangements. He goes to give familiar figures about the volumes and the price. So there is no doubt that he and several others at Octavis were aware. How were they aware? If I can invite the lordships to look over page, you'll see halfway down it was asked, did someone tell you, this is line 3, did someone tell you from people from Auden? No. We would have looked at it again through the due diligence process. And then lines 11 and 12, almost certainly in the data room. Probably a few different people would have read it. That's the first point. He clearly is aware of the second written agreement. And that'll be relevant when I come on to look at the tribunal's findings in H2. The second highlight is on this page, and it's where Mr. Wilson is asked what I might describe as the $64,000 question. It's at line 17 to 18. The interviewer says, "What was Actavis getting in return for that discount?" We all want to know. And Mr. Wilson, can I ask your lordships just to read his answer from line 20 to the bottom, and then over page to line 4, please.
Yeah.
And so Mr. Wilson quite fairly says they inherited the agreement, he's not the best person to ask where the terms came from, and I don't at all take issue with that. The bit that matters for our purposes is when he says, in terms of supply, line 22, page 17, I saw it as a B2B relationship, where AMCO's alternative was, and then clearly he's refreshed his memory by reference to documents that he's read, as witnesses commonly do. And then the last line, AMCO's alternative was using their marketing authorization, getting it contract manufactured elsewhere. And he then goes on to say that it's a different sort of part of the market from your typical supply to wholesalers who don't have that ability. And then he finishes over page line 3 to 4. That's how he understood it at the time. And it's not equivocal in any way. He's explaining that he understood supply from Auden to AMCO was the alternative. But he's actually asked about this a second time. Could I ask your lordships to have a look at that, please? So that's internal page 26. And it's halfway down to the bottom, line 16. We can see here the CMA interviewer is saying, look, I can see this is a very beneficial deal for AMCO. Making it too good to be true. And then he goes through the numbers. And what's interesting, you'll note that we're now in September 2015, and the price is about £67. The amount of the value transfer has gone up. And then he just says, I want to understand, this is line 23, 24, what the rationale is for continuing this arrangement. And then the last line, there's a very substantial opportunity cost here for Actavis in continuing the arrangement. And again, over page, Mr. Wilson says he's not the best person to ask where it came from. Fair enough. But then what he goes on to say, lines 8 to 12, he would have assumed that AMCO had an alternative supply, probably at a cost not dissimilar to our own. Assume that they were weighing up the two. And then, if I just ask the last bit, lines 20 to 22, it's would AMCO continue? Does AMCO continue sourcing, or does it go and get products elsewhere? And so we say the implication is that Actavis does know and understand that supply from Auden Actavis is the alternative to entry by AMCO. Now, the final point of Mr. Wilson is adverse inference. And we raised this in our respondent's notice at point C. So that's at core tab 16b, page 1462. And so we say, as a matter of ordinary rationality, Auden could and should have called Mr. Wilson to deal with these points. He could have been tendered for cross-examination. The CMA could have put questions to him about his knowledge and understanding of the common understanding. Auden chose not to call him. Your lordships will be aware of the approach by Lord Legate in the case of Royal Mail and Aphobie. That's at Authorities, tab 53, page 2087, paragraph 41. There's no need to turn it up. I was just going to give you 4 points derived from Lord Legate's judgment as to why we say the tribunal acted unreasonably in failing to draw an adverse inference. First, Mr. Wilson was an employee of Accord UK. That's the current name for Actavis UK. And there's no good reason given why he was unavailable. Second, it is reasonable, we say, to expect that Mr. Wilson could have given relevant evidence as to the continuation of the alleged 10 milligram agreement after May 2015. Third, we've just seen there's other evidence that was before the CMA and before the tribunal. Mr. Wilson's transcript of his interview, I'll come on to his emails at the time as well, all of which could have been put to him had he been called. And fourth and finally, we say that these points are plainly important for this case, at least in terms of how long did the alleged agreement last. Now, it's right to acknowledge that Auden, in their skeleton argument, say two things. First, they say, well, we appealed and we put the decision's findings in issue. But that's precisely the point. They appealed, but then failed to call the very witness that could have been cross-examined and his evidence heard by the tribunal to deal with the issue. The other thing they say is that, well, we, the CMA, followed an unfair process. We didn't go about this in a proper way. And as to that, we say, we respectfully disagree. We, in our written openings, and then in our written closings, and then in our oral closings, again and again told Auden and the tribunal that we were going to invite them to draw an adverse inference from the absence of any Auden witnesses, including Mr. Wilson. So we say, regrettably, the tribunal's failure to draw an adverse inference from the Auden's failure to call Mr. Wilson is unreasonable. And the inference we'd invite this court to draw is that from May 2015, Mr. Wilson did share the common understanding that AMCO would not launch its own product in return for Auden's supply of product at a bargain basement price.
The situation here is slightly different to that in DAF, where, of course, if a witness isn't called, then the entirety of the evidence is simply not known. Here, the individual had given evidence to the CMA under a form of statutory caution on one or two occasions.
One occasion.
So you were able to rely upon that evidence simply by placing it in front of the tribunal.
We were.
In one sense, if there's inculpatory evidence, you can turn to it and point to it. If the other side don't challenge it, well, then it stands as unchallenged evidence for what it's worth. Does the question of adverse inferences in those circumstances really arise? Or do you simply say, we've questioned you and here it is, this is the evidence, it supports our case for the following reasons?
And they didn't call him say anything different.
So
Which is not the same thing as adverse inference. It's just making the point that, you know, if there was something about what he said to the CMA in an interview that they didn't agree with, they could have called him to correct it.
So there were 2 points. There's my Lord, the Chancellor's point, which is that Auden activists did disagree with the CMA's reading of Mr. Wilson's transcript. It seems to me in that situation, if they want to disagree with it, by all means, but you have to call the witness so that the CMA can then cross-examine him. The second point is that the tribunal doesn't address Mr. Wilson's evidence at all. He's not even mentioned. In fact, worse than that, as we will see, the tribunal says that they hadn't seen any evidence that anyone in Actavis had discovered the second written agreement. And so even though Mr. Wilson was drawn to the tribunal's attention in our pleadings and moreover in our submissions for trial, the tribunal doesn't address it. So there's then a sort of...
That's a different issue to adverse inference. I mean, you're entitled to say the evidence is admissible, it is relevant and probative, it was placed in front of the tribunal, they failed to address it. If and insofar as the respondents to the appellants before the CAT thought it was forensically sensible to challenge it, they could have called him, but they chose not to. But at the end of the day, the adverse inference really applies to somebody whose evidence isn't before the trier of fact. That's all.
Yes. If it's not an adverse inference in the DAF sense, it is a point that says, as my Lord observes, there is this transcript of evidence. The tribunal's practice typically has been to diminish the probative value of these transcripts, and I think the CMA respectively disagrees with that and says, as my Lord does, it's admissible evidence, it's clearly relevant. We say we're entitled to rely on it and give it weight. We ask the tribunal to do the same. Perhaps if adverse inference isn't the right route by which to address this, what we do say is that the other side shouldn't be able to make a tactical decision not to call a witness, disagree with our reading of the interview, and then say to the tribunal, right, well, you must now find in our favour. We say that really isn't appropriate. So if the point is that the evidence of Mr. Wilson, which was before the tribunal, should be considered and should be given some weight, then the CMA is content with that. The problem was the tribunal doesn't grapple with what Mr. Wilson said.
But say for the procedural point, of course, you won.
Not on this particular point we didn't.
No.
And so I'm going to address you actually in terms of where the tribunal, I mean, perhaps it's helpful for me to do that right now so that you can look at what the tribunal says about it. It's in
Can I just make
H2.
another point? Because in a sense, the point of principle is important. There could be a disagreement between the parties on the construction of the transcript. The parties may say, well, actually, if you look what he said, in the same way in closing submissions, you'll go back to the transcript, said the witness said X, and the other side say, actually, you've misconstrued it. It's to be interpreted differently. That's just a debate about the evidence. Even if there's a debate before the closing submissions, it doesn't necessarily mean to say they need to call the witness to give some new gloss. I mean, it all depends upon what they said and how clear it is and what view the tribunal takes.
Well, I mean, I've shown the court the passages that we rely on. They are pretty clear. He's not equivocating.
No.
I do accept that you'd have to look at the interview as a whole.
But if we look at it, we'd simply say, yep, we read it, we agree with you. And the point you're making, I mean, it's perhaps a point of broader practical relevance, is when should an appellant call a witness? And simply because there's a disagreement about the transcript doesn't necessarily mean they should be criticised for not calling him, because the tribunal can simply form their own view.
Yes, I mean, my lord is absolutely right that there is a very important principle for the CMA in defending litigation in front of the tribunal, because, as I've said, the tribunal's view appears to be that if you produce notes of an interview, that isn't actually worth very much. In the construction cases, the tribunal basically said, if the CMA isn't calling the individual, then we're not going to give it any weight whatsoever. And as my lord observes, these interviews are carried out under caution. The individuals are told that if they lie or give misleading information, they can be penalised and potentially criminal sanctions imposed. So yes, of course, there may be a disagreement about how you read the transcript, but I suppose from the tribunal's point of view, how is the judge, how is he or she going to make up their mind? Well, one obvious way would be if the witness could be tendered. Now, there may sometimes be good reason why the witness cannot be called. I think Mr. Turner said that we accept that Mr. Patel, in a particular situation where Auden wasn't going to call him, we say there's no good reason has been given in relation to Mr. Wilson.
You were going to take us to H2. I think we need to crack on with it.
Yes,
we do, yeah.
Absolutely. So it's a core bundle, tab 10B, and the relevant page is 478, and the relevant paragraph is 137. So this is where the tribunal is making a finding that none of the acquirers of what they refer to as the holder of the Merck Sharp Dome MA, that basically is the Auden hydrocortisone business, and they say 137, we do not consider that any of the later entities acquiring that MA holder either knew or should have known of the illegal aspects of the 10 milligram agreement. Now, we say, as my Lord Justice Green observed yesterday, this really is only relevant to penalty. And indeed, the tribunal says that in the first line of 137. You need to show intentional negligence for penalty. You don't for breach of the prohibition. The second point is that, regrettably, we say the tribunal has made rationally unsupportable findings, and there are two in particular I'd like to draw to the tribunal's attention. The first is in subparagraph 1, where you'll see halfway down they say, although we note the reference to an attempt to buy off Alyssa, we were not taken to any of the relevant material. And we say, as to that, actually the material was referred to in the decision, paragraphs 3691 to 4, core tab 11, page 774. In the defence, in particular at paragraph 489C, in the supplementary bundle, tab 12, page 1264. In the CMA's skeleton argument, paragraph 74, the core supplementary bundle, tab 15, page 1480. So it's just not correct to say that this was not brought to the tribunal's attention. The second point where we say the tribunal is unfortunately wrong, and unreasonably so, is in the second paragraph. You'll see it says we accept that the written agreements would have been susceptible of discovery, may even have been known about. And then it says this, but we have seen no evidence of this. Even if inquiry had been made, the remarkable features of these agreements would have been easily discernible. And as you've just seen, my lords, Mr. Wilson told the CMA that he and others in Octavis had seen the second written agreement. Moreover, that he understood the implication of that agreement. We say, insofar as this refers to Octavis UK, the tribunal has erred unreasonably in finding that it neither knew nor should have known of the 10 milligram agreement. So that's the first two parts of the CMA's case. The third part, I've already touched on it and can therefore be brief, is that the CMA found that Mr. Wilson, again, offered the same terms that it had with AMCO to an actual competitor. And this was in December of 2015. Now, Mr. Wilson was also asked about this, and I would, if I may, like the court just briefly to see what he said about it. So if I could ask the court, please, to pick up again Supplementary Bundle, Volume 6, tab 28. I realise it will be in my Lord's bundles at tab 27. And the internal page that is relevant here is page 62.
62.
Yes.
2474.
I'm grateful. So on page 62, you have two contemporaneous emails. They're also set out in the decision. I could just ask you to cast an eye over what they say. Direct contact between competitors, one asking for favourable supply from the other. And you can see Octavis's response. And then the CMA interviewer asks essentially two key questions. Over page, you'll see line 3. How was the £1.78 achieved? Well, you don't have to be a rocket scientist to realise the answer is going to come. It's at lines 19 to 22. It was because that was what had been offered to AMCO. And then could I ask your lordships to go forward, please, to page 65, because the CMA then pressed to understand, well, why? Why were you using the AMCO supply as a model, a template for this? What was similar between AMCO and Alyssa? Top of page 65. And the key point, lines 12 to 15, is it essentially because they have a marketing authorization? Mr. Wilson, yeah, they've demonstrated they had the source, and so we're competing against that source of product. And I respectively agree. And so what we see is, unlike nearly every other arrangement Octavis has, normal vertical supply with wholesalers, Alyssa is a competitor. And so it gets these exceedingly favourable terms. And the way we put this is that, as my learned friend Mr. Turner said in opening, the Superbot judgment says you can look at indicia, coincidences. And it's an indicia that this is how ordinary activists were behaving, what they were striving to achieve at the time, and this is how they were dealing essentially with competitors on the market. The fourth element that I referred to in the CMA's case is the impression that was conveyed to AMCO, the counterparty. And there are really 2 points I want to make about this. First, there is Mr. Baton's evidence to the tribunal that Mr. Patel had told him that Octavis UK would continue to supply on the same terms after the takeover took place. Just for your reference, it's the supplementary bundle, volume 2, tab 7, page 675. It's lines 16 to 19. So that's indirect evidence that one of the chief negotiators was saying, don't worry, Actavis will continue my strategy. But then, just in terms of the chronology, it's quite interesting to look a little later on in the series of events in the timeline, and just to show you one other insight into AMCO's perspective and understanding. Could I ask your lordships just to turn up the decision, please, to the core tab 11, page 769. Your lordships haven't seen this bit before. And we start at paragraph 3.699, and this is where AMCO bought another company. This one was called Focus in late 2014, and Focus had its own hydrocortisone project. And just down the page, paragraph 3670, I just tell you the gist of what this says. There's some discussions between Focus and AMCO about how to maximise return on Focus's hydrocortisone tablets. And basically, there are two scenarios, two options. Scenario 1, supply deal with Orden Actavis. You note they're using Orden Actavis exactly the same way as we do. And scenario 2, Focus manufactures and sells its own product. Now, if I ask your lordship to turn over a page, just to see one contemporaneous email, it's at paragraph C on page 770 of my bundle, internal page 280. And it begins on the 1st of September 2015, so the date on which, at this moment, there's a reorganisation within Actavis. Mr. Baton, a familiar face, he explains the most important job that they, Focus Management, have to do for us is negotiate with Actavis Orden, get the highest level of monthly volume, I interpolate payments, and keep it there ongoing. There's no hint here of them wanting to launch their own or get in the market and compete on the merits. It's all about, let me see how much money I can extract. I'm going to gear up to leverage once again. For completeness, I should tell the court that Mr. Basin was cross-examined about this. For your reference, that's in the supplementary bundle, volume 2, tab 7, page 683. He was asked about the two scenarios, and the only point I wish to make about it is he confirmed that it showed that AMCO's perspective was these are mutually exclusive alternatives. Now I accept, as I'm sure the companies will point out, these are internal AMCO emails. They weren't sent to Actavis, and I'm not trying to suggest that they were. And no doubt because the market had moved on by this point, independent entry had occurred, Alyssa had entered, Bristol had entered, they didn't pursue this. But my point is a much more simple one. It shows you how AMCO perceived the relationship it had with Orden Actavis. We see them basically gearing up to do it all over again, to leverage the threat of entry for higher payments. And so that's just another indicia of how they are perceiving things. So we say if you draw those elements together, the Allergan takeover in May 2015 doesn't change anything. But of course the other side say, Mr. Patel, he has exited stage left, and therefore the understanding has disappeared. And we say that's wrong for three reasons. First, we say that an individual's subjective awareness of an infringing agreement isn't the touchstone for an agreement for the purposes of competition law. It would really undermine the effectiveness of competition law if one were to insist on an impossible hunt for the inner soul of a particular individual. We say, as Mr. Turner set out in opening, that as a matter of law, once an agreement's set up, it can continue by virtue of the parties' continuing course of dealings. Now, For reasons of time, I won't go to them, but can I just draw to the court's attention two authorities that we cite at footnote 35 of our skeleton that support that proposition. That's at core, tab 9, page 295. That's as a matter of law. Second, as a matter of fact, as the Master of the Rolls observed last week, it really is a simple arrangement. Ordnance Tarvis pays Amco to stay off the market. It doesn't need to be discussed. They've been doing it for 19 months. They've negotiated the satisfactory price. It went without saying. I mean, experience shows the easiest cartels to sustain are the simple ones. And it's worth noting, Mr. Patel doesn't have a Jerry Maguire moment, leaving in a dramatic fashion, telling everyone that he's out. He disappears, but actually what he does do, he tells Mr. Baton, don't worry, it's just going to continue on the same terms as before. And then third, as your lordships have seen, we do rely on Mr. Wilson's understanding that this manifestly uncommercial supply was the alternative, and instead of Amco entering the market independently. I've already addressed my lordships on H2, paragraph 137. I turn then to deal with Allergan's point. Your lordships recall yesterday, Mr. Joel submitted, they didn't know anything. They tendered a witness, he said he didn't know anything, they're just a parent company, and the tribunal agreed with that. And I accept that they didn't know anything. He wasn't challenged on that. My point is it doesn't matter. Allergan, for the period 29th of May 2015, 9th of March 2016, was part of the undertaking. It's part of the infringing undertaking. And a parent company does not need to know about the infringing conduct of its subsidiary. And I should just note, the tribunal acknowledged in its H1 judgment that Allergan and Tarvis were part of the same undertaking. And that's just footnote 380 in the Anna Green bundle, tab 79, page 2169. So really, that argument about Mr. Stewart's ignorance is neither here nor there. The next point is the point that my Lord Justice Green described as ingenious yesterday, which is where Miss Ford submitted that there had been a reorganisation within Tarvis, where the business moved from AM Pharma, the original Auden entity, and it was transferred across to Tarvis UK Limited in September. And the submission was that, well, no one, no knowledge, no mind went along with that. We say, with respect, the fallacy in that is that AM Pharma and Tarvis UK and Allergan, they're all part of the same undertaking. And it's well established that internal restructuring, corporate reorganisations, do not affect liability. And I'm very happy to say that I agree with Allergan's skeleton argument about this. And I'm going to just show your lordships this, because perhaps on this point there's a rare moment of harmony across the court. Paragraph 69, this is core tab 4, page 99. The authors of the skeleton rightly and clearly express what in my submission is the law. Paragraph 69, you'll see, second sentence, the starting point is that an undertaking may not escape liability for breaches of competition law simply by changing their identity through restructurings, sales, or other legal or organisational changes. And for your lordship's note, the authority there, sodium chlorate cartel, is at authorities 99, page 3911. There's no need to turn it up. Just simply to say, if you were to look, the very next sentence in the paragraph cited by Allergan makes the legal policy that this is justified in order to suppress conduct that transgresses the competition rules. In my last sort of 5 minutes, I'll wrap up on part 3, if I may. And this is to look at the tribunal's approach to this in H2. Now, if the court is with me that the common understanding is unaffected by Mr. Patel leaving and the intra-transfer of the business, then there's really no need to consider this issue. before we go to H2, as my Lords, the Chancellor and Lord Justice Green will be well aware, and it's their judgment, I would like to just show the court your recent judgment in CMA and BMW and VW, because there you considered the relevant concept of undertaking.
It's on appeal, isn't it?
It is, but my Lord, you haven't been overturned. I don't expect you to be overturned, and therefore your judgment sets out the law. So could I just invite you to go to authorities, it's tab 64, and it's page 2345.
Tab 64.
Tab 64, that's right. And it's under the heading Implications of EU Law on Undertaking. And the Court of Appeal helpfully summarises a recent judgment of the Grand Chamber of the Court of Justice in arising from the trucks cartel, the case of Sumau.
Which paragraph?
My Lord, it's paragraph 85. And actually, I'd like to go to the Court of Justice judgment, if I may, and that's paragraph 86, which you describe, rightly if I can say so, as an important judgment.
Right.
And in the bit that's quoted, I want to take you to 3 propositions, please. Over page in paragraph 41, I wish to draw to the court's attention the last sentence. So the undertaking is an economic unit consisting of a unitary organisation of personal, tangible and intangible elements pursuing a specific economic aim on a long-term basis, contribute to the commission of an infringement. So first point, it's an economic unit, not a company, not an individual. That's a very important point. We're about to see why. Paragraph 42, we see that about halfway down, we can see that the court says it is for that unit, in accordance with the principle of personal responsibility, to answer for the infringement. In order to hold any entity within an economic unit liable, it is necessary to prove that at least one entity has committed an infringement. And so I take from that that it's enough for one entity to infringe without the involvement or the knowledge of anyone else in the undertaking. And if I may go to one more proposition, the end of paragraph 43 over page, and it's the last 4 lines where it says, the very existence of that economic unit which completed the infringement decisively determines the liability of one or other companies making up that undertaking for the anti-competitive conduct of the latter. Now, it's important to bear those points in mind, if I may say so, when one comes to consider the tribunal's reasoning. And the next thing to say is that in this case, the relevant undertaking is Auden, subsidiary AM Pharma, at Tarvis UK, and Allergan, to the point of the March 2016. And for your Lordship's note, that is set out by the CMA very clearly at the beginning of the decision. Paragraph 1.3a, that's core, tab 11, page 498. Now, your Lordship's pointed out in your BMW judgment, paragraph 91, any person's entitled to say they've been wrongly classified as part of an undertaking. Auden did not do that. Allergan's did, and before the tribunal, they were successful. And so that is why I've said that they were only part of the undertaking until March 2016.
That was the court's judgment in Sumar, wasn't it?
That's right, my lord.
The joint and several liability doesn't override rights of defence. So if you've been wrongly classified as part of the undertaking, you have a right to challenge that, and therefore you have a right to receive an SO and so on and so forth.
Exactly right, my lord. And of course, Allergan had a right also to appeal to the tribunal as they did, and they were successful in showing that for part of the period, they didn't exercise decisive influence over Actavis and AM Pharma. And the reason for that was they had sold the generics business and given remedies to the European Commission. If I may then just invite the court to go to the tribunal's judgment in this case. So we're back to the core bundle, please. And could I ask the court to go to paragraph 1372, a different bit this time, on page 479. So after in my submission, the tribunal erred in relation to intentional negligence relating to the acquirers, specifically Actavis UK, we see, as my Lord the Lord Chancellor pointed out yesterday, the second sentence of the free-floating paragraph that says that's because the acts and states of mind of Auden, Auden's part of the same undertaking, are the acts and states of mind of these entities, that's the acquirers as well, and then pithily they say, if Auden was infringing, then so were they. Now, my lords, you'll have my point that we don't agree that you need to find some mens rea, some subjective guilty mind. But could I ask your lords to read Power 138, where I think there is reason for hope that the tribunal reached the right conclusion on this point. And so my submission is this. I would invite this court to endorse what the tribunal says there about practical reality. Competition law is at its best, where it accords with common sense, and if I may say so, practical reality. And here what one sees is that the arrangements with AMCO continued uninterrupted between the two entities. And I would respectfully say, precisely. People come and go. Corporate acquisitions happen, internal reorganisations happen. But none of that interrupts the arrangements between the competing undertakings, where the monopolist, Auden Actavis, is paying hundreds of thousands of pounds. The market price reaches its peak during this period in March 2016, where it is an astonishing £72 a pack. And moreover, Actavis is charging every other customer a price around that price, and there's one exception, AMCO, because it's a potential competitor. There might have been another, Alyssa, but they declined to take the bait. And so we say, in those circumstances, yes, there's a same undertaking, engaged in the same conduct, and therefore the inference should be the agreement continued until the market moved on, until independent entry occurred, and at that point, one sees that they realised they'd run out of road, and therefore the agreement had to come to an end. If I may just finish with one brief reference to essentially an insight to Actavis's mind on this during this period. It's in the decision. You'll find that in the core bundle at tab 11. And just to show you what it was thinking at the time of January 2016. And again, just re-emphasising really how supply from Auden Actavis was an alternative to AMCO entering. So if I could ask your lordships to look at paragraph 3.697, 3.698. So here what you see, my lord, it's page 775 or 285 internal. And what this is a contemporaneous document where Accord UK is the name for Actavis UK, it just renamed itself during this process. And you can see them setting out market developments. You can see Bristol, competitor that's just got a marketing organisation. Alyssa, that's the one they tried to buy off, which entered in October 2015. And then lastly, AMCO. Note the fact that in parentheses they talk about its R product. And then the minutes say, and this is the next paragraph, they can pull AMCO supply now. There are more players in the market. And so in a sense, what that's indicating, just an indicia, it's not in any way conclusive, but an indicia that they were looking at this as trying to hold the fort, to protect the monopoly for as long as possible until eventually third parties came in, which made the impossible to sustain. So for those reasons, we say the answer to issue 6 is the tribunal did not err, perhaps not for all the reasons it gave. It didn't err in finding that the agreement lasted until the 24th of June 2016. Unless I can be of any further assistance, those are the CMA's submissions on issue 6.
Thank you very much.
Please the court. The 3 points I'm going to cover are these. One, Mr. Brearley's ground that the tribunal erred by finding a pay to exclude AMCO agreement had the object of restricting competition, since Auden and AMCO were, according to Mr. Brearley, not truly competitors and the tribunal's approach to market definition was wrong. Two, Mr. Brearley's argument that Mr. Mitru failed to cross-examine Mr. Baton about there being a commercial rationale for AMCO not to restrict itself from entering the market, both in the early period, before Mr. Baton got involved in negotiating, and in the later period, when taking supply from Auden was said by him to be a stop-gap. Third, I'll refer to the grounds which are raised by Advance and Sinvan separately, which are really disguised appeals on fact, not law in our submission. To begin with the object point, my essential point on that is it is not a point of law that you see. You have a disagreement with the assessment by an expert tribunal on fact. The tribunal's made a robust finding as to why potential competition from Advance, AMCO, was a worry to Auden, and why Auden would be motivated to buy them off. If you open up Advance's grounds of appeal, it's in the third volume of the core bundle, page 1389, begins on page 1389, tab 13D, and the relevant ground is at page 1392. It's their ground 2. It is entitled No Object Infringement. You'll see the complaint in the first black bullet. It's that the CAT's analysis of an object infringement is insufficient, almost conclusionary, and ignores key relevant evidence. And it alleges that the tribunal has not properly considered certain matters, which are then set out. It is framing an appeal on the facts. It's the way the ground is constructed. No point of law is isolated. And if you go to the second black bullet on the facing page, 1393, the CAT adopted a novel approach to defining the market in pharmaceutical products and didn't follow its previous approach in a case called phenytoin. Well, a complaint that a market definition approach is novel is not a point of law, and in any case, the tribunal explicitly does not rely on market definition in the H2 judgment. It looks at the question in what it calls its term real-world terms, and found that AMCO's skinny label product was a competitive threat to Auden. It called AMCO an unpredictably constraining competitor to Auden. You see that immediately if you would turn up at H2 and look at the tribunal's analysis. The relevant bit is at page 462 of the core bundle. The relevant paragraph is 1153. We've looked at this very briefly before already, and to go through it at pace, Roman 1 refers to the stylised market definition approach the tribunal did use in the H1 judgment, abuse of dominance. Roman 2 says that the process of market definition is used to identify and describe market power, but it doesn't assist in informing decisions of participants in the real world, which is what it's going to look at here. Then it goes on to do that. Roman 3 refers to how skinny labelled products will be looked at by pharmacies in the real world. Roman 4, the conclusion that skinny label is an unpredictably constraining competitor to Auden. And then if you turn the page at Roman 5, tribunal backs up its reasoning by referring to hard evidence about the effects of actual market entry which has occurred by skinny label when it happened. There's a reference there to period 94, And for your note, that corresponds to October 2015. Reference is paragraph 189 of H1. When it happened, it did lead to downward pressure on the prices of both skinny and full label products. And at Roman 6, the tribunal draws the key conclusion that Auden would have been motivated, essentially, to take steps. There's one more piece of the reasoning, which is in paragraph 134, Roman 3, on page 476. I mentioned for completeness. This is 6 lines down in that bottom sub-paragraph. The tribunal says, we consider, just as the acquirer of Auden did, that skinny label would be competitors, but competitors at disadvantage. The footnote then goes to documents set out above at 128 and 129. And if you flick back, those are an advisor presentation, it was PwC, in December 2014, to the acquirers of Auden, Actavis. If you look at page 469, paragraph 129, the tribunal helpfully sets out some of that material. You'll see a table, for example, subparagraph 3, bottom half of the page, and the advisors are considering, projecting, forecasting what would happen if skinny label came in 2015. And if you look at that table, you'll see market share and price plummeting from the 2015 column to 2019. That is the evidence the tribunal was relying on in paragraph 134 of the judgment. Now, standing back, there is no attack on this by Advance which comes close to a point of law. This is the reasoning in the decision, no attack on a point of law. Mr. Brearley argues that the market definition used by the tribunal in the other H1 judgment is wrong, but that is irrelevant. He produced a note last night, which I trust the members of the court have got. In that note, it's a short note and very loosely written, he refers at paragraph 4 to a general court case called WABCO for the proposition that market definition is relevant to object infringement if the extent of substitution is not readily apparent. Let's put, if he intends to mean that a market definition exercise is needed and it wasn't done, that is not in the grounds of appeal, and it is in any case wrong. The case does not stand for that proposition. If you look at it very briefly, thank you, in Authorities Bundle 7, tab 100, the relevant page is 3927 in the Authorities. 3927, and you will see on 3927 two sideline paragraphs. The first, 78, says, giving sensitive business information to a competitor breaks the law if it's capable of restricting competition. Well, that's not a promising start to the argument, given what this court has seen happened in the present case. The second sideline paragraph considers the situation where sensitive information is exchanged between two undertakings, but they're not competitors. That's all very well, but we're not in that scenario, because the point at stake in our case is precisely whether Auden and Amco are potential competitors. And on that, the tribunal has made its factual assessment. So I say nothing more about his ground on object and market definition. I turn to the second topic, which is the argument that Mr. Dimitriou failed to cross-examine Mr. Baton about there being a commercial rationale for Amco not to restrict itself from entering the market. Mr. Brearley argued that she'd failed to cross-examine Mr. Baton properly about Amco's commercial rationale for not agreeing to this form of pay-for-delay arrangement. And his argument on the period before Mr. Baton comes into the saddle is that Mr. Dimitriou failed to challenge the suggestion that Amco had no reason to make a pay-for-delay deal at that stage. They expected to enter the market independently, they would take half of it without prices dropping very much, and they'd make a lot of money. In relation to the later period, Mr. Brearley accepts that AMCO was in difficulties with its own supply, the orphan designation skinny label issue. But he says, well, the deal at that point is a stopgap while we sort these problems out. And again, he says Mr. Mitriou didn't challenge that. So I'll be quick. First, can I remind the court that none of the questions in the company's list of fatal omissions, which was produced after the H2 judgment, concerns Mr. Baton's evidence about taking half the market with AMCO's own product. And we saw that yesterday. I won't invite you to look at it again. But essentially, they were consistently beating the drum of dishonesty, sham, and charade. Before the H3 judgment came out in March this year, the companies never argued that the CMA had failed to put a key part of the case to Mr. Baton through not challenging his evidence that it wouldn't have made sense for AMCO to have entered a delay agreement in the early period. It is an artificial point. My second observation is this. Mr. Baton wasn't involved at the time when this 10 milligram agreement started, as you know, and his speculation on this point provided no insight into the basis on which the deal had actually been done. Now, yesterday, Mr. Brearley addressed this by saying Mr. Baton himself confirmed in the box that he had been in charge throughout. No, with respect, the part of the transcript that he relies on does not show that. It shows that Mr. Baton could not assist the tribunal and that the relevant individual to ask questions of was someone who wasn't there, Mr. McEwen. So if you look at the supplemental volume 1 in mine, and I say with trepidation tab 6, but I mean the day 2 transcript of the trial, beginning at internal page 146. In my bundle, that is 461. Your external numbering may be 458. And if you read to yourself, the relevant part is lines 9 to 22. You see the question from Mr. Mitriou first, where she's putting to him the earlier situation.
Give me the page number.
I'm sorry, internal 146, day 2 transcript.
458.
Yep.
And you'll see from line 9, Mr. Mitriou puts to him that there was an understanding in the early stage, and she refers to Mr. McEwen and Mr. Vijay Patel on the AMCO side. His answer is at line 17, oh no, I wasn't involved at this time. Okay, as I said, I inherited this deal, I didn't delve into it. I spoke to Mr. Sully about it, and all the deals that Wade, Maid and Andy Farm had got, and he went away and investigated them. So that's preceding the extract Mr. Brearley goes to. So then if you go forward to 163, you have the bit that Mr. Brearley did refer to. So it's a bundle extract, possibly in yours 475.
Mm-hmm.
And if you start with Mr. Mitriou's questions beginning at line 6, this increase, threefold increase in the supply, was obviously contrary to Auden's commercial interest, was it not? And you see his answer, and dropping down, well, he says, as you can see from previous documents, somehow Vijay persuaded Amit to do this deal. We inherited it. As I think I've said, I asked Mr. Sully to investigate, to check everything was okay, and we just continued with it. Then you have her questions, you inherited the deal, but at this stage you're very much in charge, aren't you? And he says, yes. And then it continues. But if you now turn over the page to 164 and look at lines 10 to 16 to complete it, her question, we can also see, can we not, from the email from Vijay Patel, you're directly involved on the ground, as it were. He's asking you to sort out the supply issue. He asked me to. Whether I actually was or not, I don't know, because I definitely was relying on Brian McEwen at this stage. Essentially, his consistent position in negotiation was that he didn't ask McEwen or Vijay Patel about how the deal came about. he took it at face value. There are numerous references to exactly the same effect, but I'll just show you perhaps the central one. If you go back in the same transcript to 139, beginning, so this is possibly in your bundle 451 externally, internal 139, and look from line 24 at the bottom. So you've seen what he says. This is referring to the interview transcript. Did Mr. McEwen tell you he negotiated with Auden on the basis that he had a license for the product and was looking to enter in the market? No, we did not discuss the origin of the deal as it was handed over to me. Did you and Mr. McEwen discuss the inference that Auden could supply and so forth? No. Did you discuss the other? No. It's essentially no, 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 all the way through. Now, you will have seen that Mr. Baton says, well, Mr. Sully was dealing with that. Mr. Sully similarly said, I didn't know about this either. And in this supplemental bundle, if you go back to the prior tab, which should be the day one transcript, and look at page 141, what Mr. Sully says is in lines 1 to 11, internal page 141. I'm just looking now at his answer in the interests of speed. He says on the, you can pick it up from the previous page, line 17, where he said, I didn't give it thought, I just inherited it. I never thought about it. But then on this page, beginning at line 1, we inherited it. When I asked what's the basis of this arrangement, I was told VJ and Brian have arranged a supply agreement for an interim supply with Ithaca, that must mean Auden, and they've agreed to act in a CMO capacity. So I was trying to explain what I understood that to mean. Acting in a CMO, contracting manufacturing organisation capacity, means maintaining your volumes. I take Council's point. I didn't particularly look at this at the time in terms of why are they supplying at £1 a packet and more. The fact was we inherited an agreement. So he suggests it's about Auden trying to act as a contract manufacturer. Counsel, Mr. Mitri, then pursues that point, and she gets him to admit that this is nonsense on the very next page. If you just turn over for completeness to page 142, look at lines 3 to 7. She says to him, line 3, I just want to look at the maintaining volumes. Can we accept it is nonsense? It's what I was told at the time by Brian, but looking at it now, I think that probably is fair. So you see the position, in truth, is that the real witness who's needed to answer the point has not been produced. All you have is the interview evidence. And my third point is that the interview evidence placed before the tribunal of the position of Mr. McEwen, as well as Mr. Patel, was material relied on in the authority's decision. It was inculpatory. I shan't take you, in the interest of speed, to Mr. McEwen's own interview evidence, where he confirmed that he had used his position as a negotiating lever so that if Mr. Patel wanted to retain his manufacturing volumes, in other words, his monopoly, he should do the supply deal. But the reference is day 2 transcript, tab 6, internal page 139, lines 5 to 10. So standing back, there was no fatal omission by Mr. Mitriou to question Mr. Baton about events he wasn't involved in. On the contrary, the witness who could answer that was not there. He was not produced as a witness to contradict the inculpatory interview evidence. The only reasonable response to this at the trial stage, to pick up my Lord Justice Green's point, is, if not to draw an adverse inference, at the very least, to place reliance on, which the tribunal does not do in that last part of its reasoning, on the interview evidence. Now, Mr. Brearley showed you his closings yesterday on the issue of adverse inference. In the light of the exchanges today, I shan't say much about that. It simply didn't touch this point as to why they did not call that witness. The most relevant submission made by Advance in writing was, there may be a host of reasons why he is not being called, but no good reason was given. So I leave that there, and I turn briefly now to the later period, spring 2014. Now Mr. Baton is directly involved in the negotiations. Mr. Brearley suggests that Baton was not challenged on his explanation that supply from Auden was a stopgap. That is, in my respectful submission, an impossible argument. I showed you in opening the evidence given by Mr. Baton in the box about it. He referred to his perception of great vulnerability and the notion that taking a safe supply rather than risking competitive entry was the more attractive option for him. And one reference I'll give you for the note is supplemental bundle 2, internal page 27, line 15 internal to page 28, line 24. Now, I've also shown this court one other thing, which is the cross-examination of Mr. Baton on AMCO suspending the project, their own product development, ESICA. You have seen that Mr. Mitriou did specifically put the case that the supply arrangement with Auden was not just a stopgap while AMCO got its own product ready to launch. She put it very clearly. She did it on the basis of contemporaneous documents, and she pointed out that AMCO suspended the manufacture of its own product indefinitely as a result of the arrangements with Auden. Now, as the Chancellor noted, Mr. Baton was unwilling at first to accept that point, but then he gave ground to counsel when he was confronted with his own email to staff saying that the launch-ready product would not be sold. Mr. Mitriou challenged him forcefully on his initial position that the suspension visa was only short-term. She showed him the email from AMCO to ESICA suspending the product, and it didn't say that the suspension was short-term, just that it might be retracted if circumstances change. Yeah. So there is nothing in that point, and in summary, Mr. Brearley's arguments on the failure by counsel to cross-examine fairly on those matters is without substance. My third topic is Advance and Sinvan's appeals to the extent that they concern appeals on matters of fact. Both Advance's ground 1 and Sinvan's ground 3 are appeals on matters of fact. In 2002, Lord Justice Buxton underscored the need for rigour in formulating points of law for this court in his judgment in Knapp, and he also set out what Lord Justice Brooke, who was sitting with him, described as important practice, guidance on practice. And if you look at that briefly, it's Authorities Bundle 1, tab 15, and the relevant page is 253 in the Authorities bundle. The point of practice, which Lord Justice Henry Brooke refers to, you will find at 15, at the foot of that page, last few lines, where Lord Justice Buxton said it would be desirable in future, last 3 lines, if an applicant in his grounds, or in grounds supplemented by a short skeleton, sets out his case as follows: identify in precise terms the rule of law said to have been infringed, looking here at a substantive legal point, demonstrate where in the European jurisprudence the rule is to be found, by reference to the European authorities, and 3, demonstrate briefly from the tribunal's judgment the nature of the error, by reference to the tribunal's handling of the issue in question. So that's the guidance on practice. And if we now compare against that Advance's grounds in Core Bundle Volume 3, page 1391, so this is the first ground, not the one that we have looked at, but the no pay for delay agreement ground. And you'll see it suggests from the title that the ground is a contention that the tribunal's finding in H2 that there was a pay for delay type agreement is wrong, because the tribunal incorrectly assessed the evidence. And that understanding is supported by the terms of the first 2 bullets in the grounds. Number 1, the documentary evidence didn't support such an inference, it supported something else. Number 2, the oral testimony supported something else. Sinvan's grounds are framed in the same manner on page 1415. If you look at ground 3, it starts at the foot of page 1417 and then goes over to the top of the next page, partly in consequence of not grappling with the matters raised under ground 1 until after handing down H2, the tribunal erred in finding there was a collateral understanding. And you will see that this is a contention, essentially, that in H2 the tribunal erred in finding there was a common understanding about staying out of the market, which went beyond the written agreements. So if you look at page 1419 and look at paragraph 12 at the top, it's very clear. Third, the tribunal erred in not properly taking account of other exculpatory evidence, which contradicted the CMA's findings, then sets out strands of evidence below. And if you look, for example, at page 1421, 2 pages on, in paragraph 19, foot of that page, the tribunal left out of account an analysis of the contemporaneous evidence and so forth, which showed the written agreements were genuine and intended to be and were acted upon. These are complaints about the findings that were made on the evidence. At the hearing before this court, Mr. Brearley confirmed our understanding because he took the court to a series of isolated items of evidence. Now, it was said by Mr. O'Donoghue, well, that's just equivalent to what the CMA has done when we opened. My submission, no, it's not equivalent to what we did, because the issue before the court in this case, in our appeal against H3, is whether we, the CMA, failed properly to put our case. So it's necessary for us to outline the building blocks of our case and show what had been put by our counsel. On the other side, the issues raised by the companies in this court have been that the CMA's case didn't disclose an infringement. That's issue 1A. For that reason too, we had to explain our case. And finally, it's a relevant part of our appeal against H3 to point out the perverse finding by the tribunal that the evidence led at trial, this is in relation to Mr. Lifton of Isika, killed our point that AMCO cancelled the Isika project, leaving only a single thread, which was an inference from the value transfer. In contrast to what we have done, a significant part of Advance's written submissions, 45-page skeleton, and oral submissions, have been directed to showing this court isolated elements of the evidential record, like the P-off email from Mr. Bayton, and making submissions about the significance to be given to those. I merely observe, in light of the time, there's a practical as well as a principal problem if you do this for an opponent. Not only does it lead to including in the bundle hundreds of pages of additional primary documents, it imposes pressure on the other party, here the CMA, to put in further documents to correct the record, to show what the context was. And very soon you will have a situation where the whole trial bundle is going to be materialising before the Court of Appeal again. And mindful of that, and mindful of the need for economy in appeals to this court, we've resisted it. So, my lords, those are the major points. If I may, in conclusion, just say this. There are borderline cases which go on appeal to the tribunal. I said before, and I say it again, that this court has seen sufficient material now to appreciate in my submission that this is not a borderline case. The tribunal was right to uphold the CMA's conclusions in H2. Its reasoning was, although different from the way that the CMA approached it with the chronological approach and the fourfold issues or parameters that we looked at, it was solid, but it went off on a tangent on dishonesty. The finding of a conversation in paragraph 1448 of H2, which we were debating yesterday, is not essential in our submission. And even if it were, this court can uphold the CMA's conclusion without it, based on everything else in H2. And if I may, I'll just give you a few references for additional support in relation to that. If you open up H2, just want the court to be mindful of the following. first on page 477. Which is internal page 82. To remind the court that the tribunal itself, at least at that stage, 134 subparagraph 4, near the top of the page, you'll see for yourself, is talking there about the 20 milligram agreement. They're referring to the fact that it's perfectly valid to use it to draw inferences as to Auden's state of mind. And a sentence that I referred to halfway down, these agreements all have the same essential purpose, and it's wrong to so narrowly pass a course of conduct as to leave relevant material out. So in relation to Waymade, it's saying this is our appreciation of what went on, and you should take it into account in considering the later agreements with AMCO as well. Then if you go forward to paragraph 147, that is where they deal with the earlier part of the agreement insofar as it affects AMCO. And the heading, this is external page, bundled page 484, internal 89. The heading, Roman 1, is the nature of the oral 10 milligram agreement and the first written agreement. So their conclusion is that the second written agreement, which they dealt with just before, is a more aggressive manifestation of what's gone on before. They're not in a position to say with any precision how the oral agreement between Auden and Waymade was made, but no doubt the substance was as it was in the case of the second written agreement. And then they go through their reasoning in relation to that earlier period, the Waymade and then AMCO. And you'll see their reasoning, which there is very concise, and they conclude, the end of 147, for those reasons, that there is a pay-for-delay arrangement. And you'll see at 149, again, our conclusions align with those in the hydrocortisone decision. So before you even get to the second written agreement and the bit that they're focusing attention on the other side of this courtroom, you have all of this and the whole process of reasoning for upholding the CMA's decision in relation to this material. You also see, while we're there, at 147, the last few lines, which I've referred to before, that they say in relation to that part of the timeline, in short, it would have been important to Auden to maintain a high price across the market. We consider as such a common understanding would have been an inevitable part of the arrangement, so obvious it would not require express statement. And the point I've made and make again is that that reasoning is transportable across, precisely, to the earlier period. So now when you go back to 1448 on page 483, and you look at it in that light, with one final reference that I'm going to give you, you see that these conclusions are not essential to the finding of a pay-for-delay agreement. We therefore infer that there was a conversation between Mr. Patel and Mr. Baton. We know that there were conversations at which an agreement was reached. It doesn't say exactly how or what, and I'll come back in a moment to what an agreement means. Not only that AMCO would stay out the market, which is the central point, but also that AMCO would take Auden's product and sell it at around the prevailing market price, which I've just dealt with. In my submission, the only potential issue there relates to the point made by the Master of the Rolls about the reference to the agreement being reached at that point. And may I simply draw your attention in that connection, if we go forward to H3, page 318 of the bundle. Something you've seen before, that you need to be aware of how the tribunal itself understood what it was talking about. In paragraph 24, the tribunal is referring to a debate over the term collateral understanding and the fact that the CMA didn't like that term. And they make clear in that paragraph that such an arrangement or understanding may be neither formal nor a promise, nor agreement, although they can be, but which constitute an infringement. And if you go through back to that footnote, footnote 20 at the foot of that page, internal page 18, they're making the point there that we could be talking about something very loose indeed, a nod and a wink. So the tribunal is under no illusion that it's not talking about some hard promise. It's not necessarily finding that one took place on a particular occasion. And this should not be, this must not be a basis for saying that the CMA's decision needs to be remitted for a retrial, because that would be, in my submission, entirely wrong. All of the facts have been found, a full trial has been heard, the legal conclusions are here for this court to see. So, in conclusion, my lords, we respectfully submit that the CMA's appeal against the tribunal's decision, based on the dishonesty concerns, not to give final relief in H2, the new ground that I introduced after the Master of the Rolls comment, that should have permission to proceed for the reasons I've already given on day 2. The CMA's appeals against H2 in that context and H3 should succeed. In relation to H3, in my submission, it is clear that there was not a failure of due process through counsel's cross-examination, which was the gist of that judgment. Thirdly, insofar as permission is given to the companies to bring their appeals against H2, those appeals should be dismissed for all the reasons I've given. To the extent they are not, and I have in mind here only the 1448 point, this court should affirm the conclusions in the CMA decision on the market exclusion agreement in line with the CMA's respondents' notice. My lords, I'm grateful for your indulgence. I'm within time, and subject to any questions, those are the CMA's concluding submissions.
Thank you, Mr. Tanner. Who's going next?
I think it's me, my lord.
Are we just hearing from you, or are we hearing
No, I
from
think
everybody?
we've got to be brief individually. I think we've got Mr. O'Donoghue, Ms. Ford, and it's basically 10 minutes each, 10, 15 minutes each.
10 minutes each, lovely.
I would like to respond on H2, but before I do that, could I just respond to what Mr. Turner has submitted about the suspension of the second written agreement? Because I know that's an issue that has interested the court, and one has to remember that this is a submission by the CMA. We're responding to the CMA's appeal on this.
You mean suspension of the
ASICA, yes, sorry. And I just want to put Mr. Turner's submissions in context, because, and I'd like to do this if I could go to the unagreed supplemental bundle, volume
Sorry,
1.
which is the CMA's ground of appeal you're talking about?
It's in ground 2. I would have to check. I think it's in ground 2.1b.
2.1b.
No, there isn't a 2.
There isn't a 2.
2b. 2b.
The tribunal was wrong to hold that the only evidential basis for the CMA's findings of the 10 milligram agreement was the evidence of value transfer.
Yes, and then it.
Deliberately paused its efforts to obtain an alternative source.
Yeah.
And then it goes on and says that there was cross-examination about the suspension of the ASICA contract after the second written agreement, and that was evidence.
I've got it. Yeah.
So essentially, we wanted to respond to that, and the CMA keep on submitting to this court that AMCO suspended the ASICA development project. And I would just like to show the court the documents which do not support that, because it is quite clear that although there was an email saying we're suspending the contract, there was a lot of time, money and effort in continuing to try and get the ASICA product online, and also AMCO trying to get to market by other means.
Which volume do you want?
So this is the unagreed supplemental bundle, volume 1, tab 14. And so when Mr. Turner criticises us for essentially cherry picking certain documents, it is important to see what we actually put before the tribunal.
This is your closing.
This is the closing, it is my lord. So if we go to page 763, where we set out extensively the relevant emails that were in AMCO's possession dealing with events after the second written agreement. And we see at the top there that 763, 245, on the 27th of June, that's just after the SWA, we get a Mr. Colbeck advises them of the suspension of the project. And so a lot has been made of that email. But when one goes on throughout the rest of this document, one sees that AMCO did not suspend the project. It continued to try and get product from ASICA. So, for example, I mean, obviously we haven't got time now in reply, but at 768, at the top of the page, 267 and 268, AMCO asked ASICA for an update on the stability protocol, as they would still like to place samples on stability for 2013-14. 3rd of September, continued to consider an update to the manufacturing and supply agreement it had. In this regard, the same man, Carl Beck, said that the agreement going forward would need to be slicker due to the long-lasting frustration of AMCO with ASICA's poor performance and unreliability. We see, again, it's just littered, this document is littered with instances where AMCO is trying to get ASICA to develop a saleable product. And as Mr. Bayton said in his witness statement, it was not just, clause 2.2 was not just about getting the ASICA product. He wanted a stopgap because he wanted to get on the market by whatever means. That's what he said in his witness statement. And one sees that paragraph 271 that AMCO notified the MHRA of an application for an injectable form of hydrocortisone to try and get around this orphan designation issue. And we see at 273 that MHA rejects that. And then again, the next, all the pages are about AMCO chasing ASICA and ASICA still having problems. But the notion that AMCO suspended the development of this project is just pie in the sky, and it is quite wrong. Just to lift an email saying, okay, after the second written agreement, we're suspending it, and then to ignore all this evidence.
What does H2 say? What does H2 say about this evidence?
Nothing.
Nothing.
And it really does support Mr.
So this is a factual appeal by you, really?
Well, no, it's in response to the CMA's argument against us. The CMA say that the tribunal got it wrong. They say AMCO suspended development. And we say, well, no, that's, in the light of all the evidence before the tribunal, that is just simply not true. So we are not raising
they obviously did suspend development, but then they carried on with it. I mean,
correct, yes. It was only...
They carried on with it in a manner of speaking. I mean, obviously, commercial life is not black and white. You know, they entered into the second written agreement, they cancelled ASICA, they told all their staff they'd done a wonderful job.
Yes.
And then they go back to saying, well, what are we going to do later? because we're going to have some product someday, aren't we? And off they carry on chatting to Issachar. But, you know, that's all fact. It's all a big argument.
But all I'm trying to impress upon the court that it is incorrect to say that AMCO suspended the development of the ASIC.
We're not retrying this case from scratch on the facts. You know, that's the problem with all this approach. You've got to get permission to appeal if you wanted to reopen all the facts.
But that is my point. This is not relevant to any of our appeal.
No.
It is in response to what the CMA are trying to...
It is really, because you're saying none of the commercial background was put to the witnesses.
No, this is... Well, we put this in order to respond to their appeal. It is there, obviously, for our appeal against H2, because this constitutes relevant material that should have been considered. And it's not considered. And that takes me to what I want to say about H2, if I may. Because I'd like to make 2 points on H2. First is that H2 and H3 must be read together. That's the first point. H2 and H3 must be read together. And second, H2 in isolation failed to consider relevant evidence. So I just want to briefly deal with these 2 points. H2 and H3 must be read together.
Well, I mean, that's obvious in one sense. In another sense, do you say that the process of deciding facts and then saying that those very same facts need further argument is a good idea?
Well, the punchline of the submissions is either this court finds in favour of the appellants because we say that we have the better of the evidence, or there has to be a retrial. And why does there
have to be a retrial if the tribunal's findings on the evidence that they dismissed the appeals, all your grounds failed, is sustainable?
And I will try and show that in H2, when the tribunal said you lose, advance, that finding is based on failing to consider material evidence. And therefore, the finding in H2 cannot stand.
So what's the relevant evidence in a nutshell?
In a nutshell, it is the commercial rationale.
Yes, well then we're back to where you opened.
Well, we've made submissions about this already.
Well, no, there's two separate...
replied to it.
It's 2 separate things. In H3, we have submitted that commercial rationale was not sufficiently challenged. Now, it may well be that the court says it was sufficiently challenged.
Well, I'm not sure that's what you did say in H3. I mean, H3, certainly Mr. Turner says you never complained about what was challenged until the judgment came out.
Well,
the argument was about dishonesty.
Well, the argument was definitely primarily about
I mean, look at your document, your
We
own
were
document.
you were given a document. Yes.
Well, that document was simply, we were asked to put some questions by way of cross-examination.
It's all about dishonesty, right?
It is, but at the due process hearing, maybe we should quickly look at it, at the due process hearing, the 50% point was raised. So it is wrong to say that the 50% point was not raised by the tribunal at the due process hearing. And maybe this is a good segue into the... If we can go, for example, to the agreed supplemental bundle.
Yeah.
Volume 6. It may well be, it's... So this is day one. Internal
I need a page, Mr. Brealey.
Yeah, it's for my lord. It's 2645. 2645. It's page 79 internal.
Which day are we in?
Day one.
So the very beginning of H2. Beginning of H2.
The very beginning of the due process hearing.
I'm not sure I'm in the right place.
So this is agreed supplemental bundle.
Supplementary bundle.
Well, it's volume 6 for me. It may be.
Professor Mason said his screens weren't working.
Well, if one goes to line 20.
Sorry, give me the page number again.
79. 79.
Yeah.
So the 50% market share point is squarely raised in the due process hearing.
Sorry, I don't see where.
Well, it is at page 79, line 20. And
I wonder if we could turn to the closed judgment to paragraph 71.
71, I'm going to come to that because that
This is
relates to
where
my
Mr.
second point. But all I'm trying to show the court is that it was in the tribunal's mind, the 50% point.
71 of H2. Right?
This is 71 of H2, yeah. We haven't got H3 yet. And I'm going to come on to 71 in a minute, because it is important. And I'll try and do this as quickly
I mean, this
as
is
I can.
Mr. Jones talking.
This is the President talking to Mr. Jones. Just before we raise 2 points for you to think about over the short adjournment. First of all, can we go to H2, 71, and we'll go to that in a minute. But all I'm trying to show the court is that it wasn't solely about dishonesty. The 50% point was in the tribunal's mind. And the tribunal specifically refers to the CMA paragraph 71 of H2, which is a very important paragraph in H2. And whether or not this was raised in the due process hearing, clearly the tribunal found that there were coherent explanations for AMCO's conduct. And that is very important.
Well, that was its whole point.
But if one goes to H3, H3, at page 391,
There you go.
145. So there are 2 points to make out of paragraph 245. The first,
145.
sorry, 145. The first is that the tribunal holds that Advance has given coherent explanations of AMCO's conduct. We see that in subparagraph 2 and 3. We then, in subparagraph 4, get the due process point, the cross-examination point. But I pray in aid the findings of fact in H3 that the explanations were coherent. The 50% point and the stopgap point. That is, those are findings of fact on the evidence. And
What does coherent mean? Is it understandable or strong? Coherent
well-
means it has an understandable basis to it.
yes, I mean, I looked at that. Well, it's more than plausible. I mean, and I gave, there's other descriptions of it. It's clear, it's reasoned. So the tribunal describes it as reasoned, articulated reason.
But what does the
coherent.
court do? I think we can understand what coherent means. What does the court do if we read H2 and H3 together, and H2 and H3 reach inconsistent, totally inconsistent findings? What does the court do in that situation? How can it read them together when the process has been so fatally flawed? What the process has achieved is to decide facts and then question the basis of the decision of the facts and decide different facts.
Well,
That doesn't work in a legal process because you have one bite at the cherry, don't you, Mr. Brealey? All of you. You go to court, you put your best case. If you didn't put it well enough, you lose, and if you did put it well enough, you win. And the court finds. But what we've got here is this very unsatisfactory position of the court finding facts clearly and unequivocally, and then reconsidering and coming back and finding different facts. And you say we've got to look at it all as one piece and make the best of it. I don't see how that's a feasible analysis.
can I just make one point on that and then come on to H2 paragraph 71? Which
Yeah,
is
well, I want you to have an opportunity to answer it because it seems
yes.
to me quite significant.
because there is an order by the tribunal,
Yeah.
which the court may have seen, but it is in the agreed core bundle at tab 18. So it's not just a question of a reasoned decision. There is an order of March 2024.
So
And
this is in the core bundle.
It's,
tab
1467. 1467.
Yes. Which bit of the order do you want?
So it's paragraph 1. It says that Hydrocortisone 2 be published openly with the rider
Yeah.
articulated at 151, which is part of the judgment.
Yeah.
And the rider says that, as we know, that H2 and H3 must be read together.
That doesn't answer my question.
Well, we say it would be unfair to the appellants to ignore the findings of fact.
The rider doesn't say they're to be read together. The rider is said to be read in the light of H3, and H3 is the judgment. And then he says that is because the provisional findings made against witnesses called are unsafe and are repudiated by the tribunal. They were made because of the failure on the part of the CMA to observe fundamental principle of due process. For that reason they cannot stand. So that seems to me at least to be not talking about reading them together at all. Saying they can't stand because they weren't properly cross-examined to.
And if that's wrong,
Yes.
then there must be some, I mean, if that were wrong, I'm not predetermining this, but if that were wrong, then there must be some consequence.
Then, in my submission, what then happens is that if they're not read together, if this court feels able to ignore those findings of fact, those coherent explanations in paragraph 145, and we say it would be unfair to the appellants just to airbrush those findings of fact out, because the tribunal has said they are coherent.
But if
But
it's an
if we thought
afterthought,
the whole process, the whole due process, that way, was fatally flawed and should never have happened, then there's no point saying, well, we've got some findings in this judgment which ought never to have been delivered, which help us, because on this hypothesis, the rider falls away and we're left with H2.
or we're left with your point that there has to be a retrial because the whole thing is so fatally flawed. I mean, I do get that submission.
Yeah.
Don't
And and then I'll finish because I know others.
Yeah.
What I would like just to expand on that last point that we've just been looking at, because we need to go to H2. Well, first, we go to.
I mean, you've got another point about H2, of course, which is that you say you can't cherry pick.
You can't cherry pick.
I mean, you say it's all very well, but the thing is so schizophrenic, if I can put it that way, that you can't decide which split of the personality you like.
Mr. O'Donoghue is going to be doing the schizophrenic thing. He'll be very good at it. Very good at it.
Not personally.
Could I two paragraphs in H2 which are very important, and then I want to refer to a submission that was made yesterday, and then I'll close.
Okay, which
And
paragraph?
so paragraph, this is H2, paragraph 147, this is page 484. This is the paragraph that Mr. Turner just took the court to, where he said it was, this is concerns the first period. Let's say this is 2013. And he said the reasoning was quite concise. It is concise because it only refers to the massively reduced price. So there is inference here of a pay for delay because of the reduced price. Now that is the only real analysis we get on the first period, the 2013 period. I would like to go to page 440, which is the paragraph 71 that the tribunal referred to in the due process hearing. And in my respectful submission, paragraph 71 is a very important paragraph because it opens with Mr. Baton had a clear and sophisticated knowledge of the markings in which he was operating. This is evidenced by an exchange. Baton explained the approach he would have taken if AMCO had been in a position to enter the market for immediate release hydrocortisone tablets in competition with order. The evidence we quote did no more than repeat, in terms healthily responsive to the questions put to him, the content of his witness statement. And in his witness statement, he said he would have taken 50% of the market in a normal generics market. We see there the evidence that we've seen before. Typically, this is the evidence he gave to the tribunal. This is the typically bit in H3 that we've seen a few times. But it's all about him. If he had had product in 2013, he would have gone for 50% of the market. One goes over the page to 441. Thus, Mr. Baton disagreed with the suggestion that in the longer term, arrival to an incumbent would increase supply in this market. Supply would be unilaterally limited by the competitor in order to avoid a price war and to maintain margin for both incumbent and competitor. We accept this evidence.
As an accurate description of how this market works, as an incumbent and a single competitor entering this type of market. So I mean, that's as it were a general market statement. What it is not saying, as I read it, is we accept that that is what happened here, where these people were buying this stuff at a 97% discount. That's not what it's saying. You're cherry picking this, really. One paragraph in the judgment because you think it suits you. But you have to read the whole judgment, and the whole judgment makes some pretty devastating findings against the defendants.
But
this is just one paragraph.
Well, but it actually goes to the heart of a pay for delay. And we saw this yesterday. I don't know whether the tribunal has got the transcripts from yesterday, but if not,
we don't like looking at them, but we have got them. I think that one is reaching the law of diminishing returns when you go to the transcript of what we heard yesterday.
But Mr. Turner referred to the Servier case yesterday.
Yes.
And he made the submission, and I'll read it out. So he said, and this is at page 189
Yes.
of the transcript of day 4, line 19.
Yes.
So he submitted, and this is from the survey. The
We've
recent.
had two versions of the transcript so far, I'm sure.
Why? Yes.
Get another one at some stage.
There was admitted a break.
Anyway, Servier, he said,
the essential point is the same. To have an agreement where one party pays essentially a challenger So to have an agreement where one party pays essentially a challenger enough money to make it worth their while to stay off the market
Yeah.
and avoid the risks of competition. That would constitute a pay for delay and object infringement. But the European Court was saying that the essence of a pay for delay is that the person is being paid enough money to make it worth their while to stay off the market.
Yeah.
And my simple point is that in 2013, he was not being paid enough money to stay off the market.
Well, it was much less than in 2014
Well,
and in 2015 and in
well, it was because
2016.
prices were going up.
Yeah.
But can I just, and then I'll finish. The facts in 2013 were completely different to 2014.
Yes.
And we see from the closing submissions at Annex 1 the emails supporting this, supporting the fact that they terminated supply, they decided to launch their own, and
I mean, we do get your. I mean, I don't want you to feel discouraged, Mr. Briley. We do get your basic point that this is a complex, evolving commercial situation which cannot be treated in a binary fashion.
yes,
And that it changed in 2013, it was different again in 2014, 2015 and 2016. And to broad brush the whole thing and say it's just a simple anti-competitive arrangement, the same anti-competitive arrangement throughout, is oversimplification. And you say that was not put, and Mr. Baden was not given the opportunity to tackle the different periods of time and the different commercial imperatives at the different stages. And had he been so, he would have persuaded the tribunal, as he effectively did in H3, that there was a rational commercial explanation for what he did at every stage, which was not something that crossed the line in an anti-competitive agreement, Chapter 1, prohibition infringement.
and my only gloss to that is that all my submissions for the last 10 minutes are premised on that the CMA, Mr. Dimitriou, challenged everything that needed to be challenged. So we're not talking about any breach of due process. We're talking about whether the tribunal in H2 ignored relevant material evidence about whether it was worth AMCO's while to stay off the market. So the legal error in H2 is ignoring that evidence, because all it does is say, well, I'm going to infer the pay for delay because of the reduced price, but it ignores in H2, if one's looking at H2 in isolation, the tribunal is ignoring the accepted fact that it would not be worth AMCO's while to be paid to stay off the market. That is a relevant and material fact which is not factored in to the conclusion. So my complaint, I'm not referring to any due process point or any failure to challenge the evidence by the CMA. My complaint about H2 is directed to the tribunal, and the tribunal not considering properly the coherent explanations that it had in front of it. And we know that one was coherent because paragraph 71, it accepts it. So that is my complaint, a failure to consider properly relevant and material evidence.
And in your grounds of appeal, Advances Grounds of Appeal 13D, page 1391, where's that encapsulated, if you don't mind just helping?
Well, can I pick it up in the skeleton?
No, let's look at it in the grounds of appeal. These are your grounds of appeal.
Because you've got three, you see. You've got You've got round 1, no pay for delay agreement, which I think is where it is. I just wanted to know which sub.
Which bullet point is it?
It's bullet 1. On the contrary, the document supported advances desire for independent entry. Coherent entry. So it's the bullet. It's the first and second bullet.
Yes.
Yes, bullet 2, isn't it? Really? Okay.
I mean, that's your big point.
Here's my big point, that if you are going to set aside H3, then the question is, H2 in isolation, is it good enough? And we say it's not.
Yeah, I see. Thank you, Mr. Brealey. Your submissions have been very helpful, if I may say so.
Thank you very much.
Mr. O'Donoghue.
My Lord, I will obviously focus on the reply to the H2 appeals and not deal with the H3 appeal. It is important in my submission to take a step back from the blizzard of written and oral submissions and look at the essence of what the CMA is asking the court to now do. The CMA says, in essence, you should uphold H2. But this submission is predicated on a series of very surprising things. First, it says you should do so despite the fact that H2 does not deal at all with the issue that the CMA says is the central document in the case, the email of the 15th of June 2014. It says that doesn't matter. Second, it says you can uphold H2 despite H2 not dealing either with the other 6 documents Mr. Turner took you to. And again,
It does deal with, I think, 3 of them, actually, at different stages. I haven't counted just the second, but I think you're right, it doesn't deal with certainly all
well,
the 7.
Mr. Turner's submission was that it didn't deal with them.
Well, it does mention 3 of them. I mean, I'm not being accurate, it may be 2, but it's some.
In any event, there is a substantial complaint.
But it certainly doesn't deal with them in a coherent, logical order and say this adds up to a row of beans.
No, and that is Mr. Turner's complaint, in effect. Now, Mr. Turner, of course, goes further. This is the third point. He says you should uphold H2, notwithstanding the fact that it fails to refer to contemporaneous documents generally. And the quotation he gave on Wednesday is, "You will not find those relied on and analysed and assessed in these judgments." And he says, and I quote, "There is almost no recognition of the evidential material." And again, he says that doesn't matter, H2. Fourth, he says you should uphold H2, despite H2 rejecting the CMA's case on the ASICA project. And Mr. Turner goes as far as to say in the context of H2 and 3, that is a perverse finding. And again, that's all fine, according to Mr. Turner. And he says you should uphold H2, notwithstanding that, according to the CMA, H2 fundamentally misunderstands what the CMA's case is. H2 squarely finds that the CMA's case is that there were lawful written agreements and unlawful unwritten side agreements. The CMA, in the context of H3 in ground 2A, says that that is wrong. So the CMA, in the context of H3, appeals that as an error, but then asks this court, in the context of H2, to effectively rubber stamp that point. And indeed, one can go further. There are at least 2 other incongruities. First of all, there is the point that the H2 findings, of course, are vitiated by the fundamental error, he says, of having regard to dishonesty at all. So that is a further mistake, he says, in the context of H2. And of course, the final point, which again has been just disavowed, is H2 at 1448, in terms of the side agreement between Mr. Patel and Mr. Bateman. You can also put that to one side. Now, in my submission, it actually gets worse, because as Mr. Brealey showed you, H3, in practice, reverses all the material findings in H2 and makes a series of other findings that are, on any view, contradictory, at least to the conclusions reached in H2. And as I showed the court, a number of those points were in response to very detailed substantive submissions made by the CMA following the consequential hearing in the light of H2. And as I showed the court, those submissions on the CMA's part were not limited to dishonesty, but traversed a number of other substantive matters, such as the ASICA project. That is the 26-page document I showed you on Friday. And when the Master Rolls asked Mr. Turner yesterday, well, why didn't you immediately run off to the Court of Appeal and say H2 is an outrage in terms of setting up this dishonesty straw man?
Didn't have to get that.
And his answer is very revealing. He says, well, we thought we could change their mind, and having failed to change their mind, including through this 26-page substantive submission, he now says, well, we should ignore the findings in H3 completely and revert back to the few cherries remaining within H2 that the CMA now likes. Now, in truth, if you strip away the 7 points I've identified, strip away the reversal of the findings in H3, all Mr. Turner really likes is the punchline in H2 that he wins, and effectively nothing else. Now,
We all like that.
well, he's asking you to uphold a £250 million quasi-criminal penalty against the undertakings and the individuals, leading to direct disqualification, damages actions on the basis, effectively, of a sentence that he likes in H2. And let's call a spade a spade. Now, then, of course, we get to our appeals against H2, which, again, Mr. Turner wants to completely airbrush from the picture. Now, one of the points we make, of course, in our appeals is that the H2 finding of an unlawful agreement is not based on the findings in the decision and is based on this side agreement that was not part of the decision and has now actually been disavowed and was not therefore cross-examined on. And here, of course, bizarrely, the CMA and the companies essentially agree, because Mr. Turner said on multiple occasions on Wednesday, H2 strikes its own course, it is a different approach to the decision, and it plots a different course. We, of course, also made the point in our appeals that nowhere does H2 deal with the point now accepted in paragraphs 26 and 83 of H3, that one explanation for the value transfer is that Auden unilaterally wanted to incentivize AMCO not to enter the market, but there was no Chapter 1 agreement to that effect. That was the original theory of harm I showed you in the first statement of objections, which the decision now says at 227C, and I quote, the CMA no longer relies upon. So there was an explanation advanced by the CMA itself. There was a complete explanation for this value transfer that they no longer rely upon. And H3 accepts that.
What troubles me, Mr. O'Donoghue, is that all these arguments are terribly binary, and economic life is much more complex than binary arguments. It's not sensible to say Auden, the explanation for everything that happened over a 4-year period is Auden wishing to incentivize AMCO not to enter the market and nothing else, when you have 4 years of communications and other conduct taking place. And it's equally very binary to say that the only thing that matters is a conversation that the CMA, that the tribunal has found to have occurred without any evidence that that conversation had the content they ascribed to it. It's too complicated, and we all make these submissions as if, you all, not we don't make any submission, but you make the submissions as if this is sort of the explanation, the answer, the entire answer. Commercial situations are not like that.
Well, I quite agree. And the point I made on Friday, and I reiterate now, is it really is very unsatisfactory in a 41,000 document case for Mr. Turner to say, well, here are my 7 cherries, Mr. Breedy to present another bowl, and to ask your lordships, well, which cherries would you like to pick? And there is a very serious fundamental point at the heart.
There is a serious fundamental point, and the serious fundamental point is that justice has to be done.
Well, yes.
There has to be finality, and that was not achieved. Now, what's gone wrong has left us with a really serious problem, because we had a tribunal that found one way and then found another, effectively, another way,
yes.
On a different factual foundation, and we have to unpick that. Now, your submission could be, quite properly, I think, it's so unsatisfactory, because I don't think either side is saying the process that was followed is satisfactory.
No.
And I think you're saying, if we unpick what you both are saying, is you can't cherry pick from H2 the bits you like, because H3 and other bits of H2 are inconsistent with it.
Yes.
And therefore there hasn't been a proper fair determination of the facts, by which we should be bound in a quasi-criminal proceeding and fined $250 million or pounds or euros or whatever it is. You must have a retrial. Now, is pretty unsatisfactory to people sitting here.
We are not gagging for a retrial.
No, I'm sure nobody is gagging for a retrial, but it is, I think your ultimate submission is, if that is your conclusion, that is the correct outcome.
Yeah, well, my Lord, I do go further, and indeed, the most neutral way one could put this is as follows. Mr. Breedy gave you a taste of the 394 paragraphs of contemporaneous material he put before the tribunal.
Yes.
We had something similar. And with the greatest of respect, in my submission in H2, and in a sense Mr. Turner agrees with this, there has been a catastrophic failure to grapple with the contemporaneous material. The whole thing is essentially considered in a vacuum. And what should have been done is very simple. It was the point the Master of the Rolls made on Wednesday. You start at the beginning, you go period by period, you look at the evidence on both sides, and you form a judgment as to who is right on the balance of the evidence. And that has not been done, certainly in H2. And for that reason alone, we do say that presenting this court with a number of cherries is profoundly unsatisfactory.
But the logical consequence of that submission is that it has to be a retrial.
Well, depressingly, I'm afraid so. And now, finally, my Lord's, a couple of points to kind of this forward. A very good question is, well, how on earth did we get to this point? Now, one explanation, which is very important, Mr. Jowl touched upon it. We had this ambulatory draft process, which was a good faith attempt to have something approximating chronology. As the court will see in paragraph 24 of H1, the CAT itself described the ambulatory draft process as a failure.
Sorry?
A failure.
Oh.
Paragraph 24, page 1. Now, one of the consequences of the ambulatory draft process, whose failure was not appreciated before trial, was there were no oral openings in this case before trial, and we were told you can put in written openings at trial if you want, but we are very unlikely to read them given the ambulatory draft process.
What's the ambulatory draft supposed to be? I mean,
It is essentially supposed to be a neutral statement of facts and chronology.
a sort of chronology to which everybody adds.
It was sort of a team effort. Of course, my Lord, as you will have picked up, the last thing a bunch of lawyers can do is agree anything. So that the process failed. It was unbelievably expensive. It was very well intentioned. The idea was that there would be something you could cut and paste into the judgment, but it was a failure. Now, one of the consequences is no one opened the case. We were not effectively permitted to put in written openings. We were told you can, but they won't be read. And so by the time it came to judgment, the CAT had a rather fragmented picture, and it was difficult to put Humpty Dumpty back together again. And that, in my submission, is what happened and went wrong. Now, of course, as I indicated on Friday, there was then a quite involved post-H2 process at which a whole series of substantive points, rightly or wrongly, were made on both sides. And of course, things had moved on.
Yeah.
Now, notwithstanding all of this, frankly, mess, Mr. Turner says, and I quote, H2 is robust. And what he's effectively saying to the court is, you should prune off the bits of H2 he doesn't like. You should graft onto H2 bits that are not in H2 at all, and which plot a different course to the decision. And you should apply the weed killer to kill off completely H3 and all of our H2 appeals. And what they're proposing, in my respectful submission, it is not even Frankenstein's monster. It is that one can raid an entirely different spare parts bin and come together with a beast that bears no recognition at all to what was considered below, or indeed by the CMA itself. I would suggest that that need only be stated to see that it cannot be right. And it is, of course, finally deeply ironic that in a case ostensibly about a fair process, that the CMA would propose such an obviously unfair process. The Master of the Rolls said last week there is an issue in this case about the reputation of this jurisdiction when it comes to major cases like this. I would respectfully suggest that what the CMA is proposing now would risk exacerbating rather than remedying this problem.
Thank you very much, Mr. Ms. Ford.
My Lords, I have one correction and a number of points in reply. The correction is this. Mr. Turner yesterday characterised my submission as being that an agreement between potential competitors which incentivises one of them to stay off the market isn't a breach of competition law. Transcript day 4, page 180, line 23 to page 181, line 2. I did not make that submission. My submission was that the CMA has not shown anything going beyond unilateral conduct sufficient to establish that there was any relevant agreement at all. The authorities that Mr. Turner referred to, Lundbeck and Servier, are pay-for-delay cases in which the commitment not to enter the market was clear on the face of the written agreements. That is, in our submission, in direct contrast to this case, in which the existence of such a commitment is exactly what the CMA must prove as a matter of fact. And I simply draw the Court's attention to paragraph 27 of our skeleton argument, core tab 7, page 221, which cross-references the relevant paragraphs of the authorities to make good that point. That was the correction. Just turning to the reply points. The Court may have seen that in response to the CMA's new notice of appeal against Hydrocortisone 2, we have put in a respondent's notice. What it does is simply to repeat for good order the relevant respondent's notice points that we raised in response to the CMA's appeal against H3. And the reason we did that, and what in our submission it means, is that if the Court were to accept the CMA's invitation to revisit the Tribunal's factual findings and excise those relevant parts that the CMA doesn't like, then the point about the Tribunal exceeding its merits jurisdiction and the point about the duration of the common understanding exceeding beyond May 2015 still fall to be determined. Dealing briefly with those 2 points in turn, first of all, the merits jurisdiction. Mr. Turner first tried to suggest that the reference in paragraph 1448 to an express conversation was not in fact a reference to an express conversation. That, in my submission, is unsustainable on any fair reading of that paragraph of the judgment. Secondly, Mr. Turner relied on the Tribunal's powers to reach any decision the CMA could have done. And he made the point that that in turn confers on this Court the power to do the same. And that is correct. But the Tribunal, and therefore this Court, is still confined within the scope of the jurisdiction to decide an appeal on the merits. And so this is not a power to make any decision whatsoever that the CMA, in theory, could have reached were it to start from scratch. If that argument were to succeed, it would also require Mr. Turner to persuade the court that this finding of an express conversation can fairly be disentangled from the remainder of the tribunal's factual appreciation and can be disregarded as inessential to the tribunal's reasoning. And in our submission, that is equally unsustainable on a fair reading of Hydrocortisone 2. Turning to the duration of the common understanding, Mr. Bailey made submissions on what he described as the 4 core elements of the CMA's case, and those submissions were essentially submissions on the facts. And they are facts that the tribunal has considered and rejected in paragraph 137 of Hydrocortisone 2. And in our submission, for all the reasons that have been now canvassed on both sides of this courtroom, it is not appropriate for this court to go behind those findings of fact and seek to revisit them on appeal. Mr. Bailey, potentially anticipating that objection, has sought to couch his arguments in terms of a rationality challenge to the facts, but this is the first time that it has been put in that way. The CMA's respondents' notice does not put it in terms of a rationality challenge. Now, given that the factual points were raised for the first time this afternoon, I do not have anywhere near the amount of time I would need to deal with them fairly. So what I would request is permission to put in a brief note dealing with the factual submissions that were made.
3 pages.
Grateful.
By Friday evening.
My lord, yes. The remainder of Mr. Bailey's submissions were, in our submission, eliding 2 things. The first is the question of liability when an infringement has been established, and the second is the prior question of the existence and the continuation of an infringement. And what we are concerned with in this case is that prior question of whether there was a common understanding, and that is at the heart of the CMA's case. The CMA accepts it's a necessary ingredient of any infringement. It accepts it has to show a meeting of minds or a concurrence of wills. And if the tribunal, if the court were to revisit Mr. Turner's opening back on Wednesday, he fully accepted that one has to show a meeting of minds or a concurrence of wills. That is what this case is concerned with. And in our submission, the various points that Mr. Bailey then made are concerned not with that meeting of minds or concurrence of wills, but with the question of liability when one has an established infringement. And so he made the submission, for example, Mr. Patel's subjective awareness is not the issue. Well, in my submission, yes it is, if you want to show the requisite common understanding came into effect and continued to exist. He also made the submission that restructuring doesn't affect liability, but it does affect whether there is any infringement ongoing at all. He drew this court's attention to Volkswagen and BMW, but that is also talking about liability for an established infringement. And he referred to what the tribunal said at paragraph 137 of Hydrocortisone 2, and he read out the tribunal's observation: if Auden was infringing, so were they. That, in my submission, begs the key question which has underpinned this case. Was Auden infringing? Was Auden infringing? To which the answer is only if the common understanding continued. My lords, finally, on the market definition question, simply remind the court in response to Mr. Greeley's note that we have adduced our supplemental skeleton, and that is in the core bundle, tab 8 at page 255. My lords, unless I can assist further,
No,
those are my
thank you
replies.
very much, Ms. Ford.
My
Yes,
lord,
Mr. Chow, you're
Four
the
very
last,
quick
last man
points.
standing.
I am. 4 very quick points. Finality, I wish to address you on. Dishonesty, 1448, and this court's jurisdiction. Mr. Turner invoked the principle of finality. If he means by invoking that principle that once H2 was handed down, he is saying it was too late properly for the tribunal to change course, we respectfully disagree. It is now accepted that the tribunal was not functus
And it is clear on its face that the tribunal made its judgment provisional, its H2 judgment provisional, and dependent upon the consideration of further submissions as to whether the CMA's case was properly put to the two witnesses. The fault in the present proceedings is not that it was too late to reverse H2, it is that it was too early to hand down H2. If it was appropriate to hand down H2 at all, which we say it wasn't, then it should never have contained any findings, even provisional, of dishonesty, or indeed any other findings in ostensibly unqualified terms, in circumstances where the full effect of the witness evidence had not yet been taken into account by the tribunal. Dishonesty. Mr. Turner again stressed the judge's focus in H2 on the importance of dishonesty in inspiring the further stages and the further submissions. But it is important to be fair to the tribunal and not to create a straw man of the tribunal itself, because there is one error it clearly did not make. The tribunal did not make an error of law in thinking that dishonesty was a necessary element to find in a competition law infringement of this nature. And one can see that because it says not once but twice in H2 that it recognises that it is not an essential element. I won't take you to the core bundle, but you can read it in paragraph 24.3, subparagraph 3 on page 418. It states, "We accept, of course, that dishonesty is not a requirement to find an infringement." And it says it again in paragraph 24, sub 5, where it says Mr. Mitriou, KC, submitted correctly that dishonesty was not a necessary ingredient of the Chapter 1 prohibition. So the nature of the tribunal's concern was not that it needed to find dishonesty because it is a legal requirement. It never thought it was a legal requirement. Rather, the tribunal considered that the nature of the findings that it was required to make in order to uphold the CMA's decision implicitly involved conduct that could be regarded as dishonest, by which it, in my submission, meant improper conduct. Now, it shouldn't be controversial that a finding of competition law infringement can entail making a finding that is tantamount to an allegation of improper conduct by an individual. For example, if it is alleged that there has been a price-fixing agreement and the particulars provided are that it is alleged that the price fixing was achieved by a deal struck between two experienced CEOs who had had competition training, but nevertheless in secret conspired to fix the price of their products, that is an allegation that involves inherently a finding of impropriety or dishonesty in a colloquial sense. And if those CEOs are called and they provide evidence in which they deny in their witness statement that they ever spoke to each other, then it is very hard to see how in a case like that, that it will be possible to find against them without implicitly finding that they were guilty of misconduct, and indeed that they had been dishonest in their witness evidence. And so the reason that this had significance for the tribunal is because as a finding of impropriety or dishonesty, it was important that such an allegation be put fairly and squarely to the relevant witnesses. And under English procedural law, where a factual allegation in relation to an individual amounts to an allegation of misconduct, then there is a heightened obligation to put that allegation clearly to the witness so that the witness can explain the position. Now that, in my submission, is where the tribunal is coming from on this and was coming from. And that is, in principle at least, an entirely reasonable concern. And the tribunal had jurisdiction to leave open its final determination until it had got to the bottom of that concern. Indeed, I would go further and say that the tribunal was obliged to get to resolve its concerns over that issue and to reverse any provisional findings if it found that the case was not properly put in light of those concerns. It didn't have to stick with its provisional findings in the interest purely of finality. Thirdly, I come to the conversation at 144.8, and I wish to just make one simple point about that, which is that this is, it is, as we've said previously, an express, undocumented conversation at which a deal is said to have been struck on terms including price. And that case was not advanced by the CMA and was not put to the witnesses. And the simple point is this: on no reasonable view can that finding in 144.8 be interpreted as a reference to the threat or bluff exchange on the 15th of June 2014. It simply cannot. It is a completely different type of allegation, and it's not what the tribunal had in mind. And one can see that because in the 8-3 judgment, the tribunal goes on to consider the bluff, or the, as it calls it, or the threat, in paragraphs 81.5 and in paragraph 112 of H3, and it clearly doesn't regard that as amounting to anything sufficient crossing the line. So it can't be equiparated with the conversation that it found in its previous judgment. So those are that's the point there. So what one does need to do then is to try to, if one were to try to salvage H2, would be to try to swap out core findings, swap in other findings, add other findings, abutting those, and create, as Mr. O'Donoghue has described, a sort of Heath-Robinson contraption. My final point is this court's jurisdiction. Of course, we accept that this court has the same jurisdiction as the CAT, as it rightly found in my submission in the FX case. But the fact that it has that jurisdiction does not, of course, mean that it should always exercise that jurisdiction. And it should bear in mind that it is an appellate court, and it's not appropriate for an appellate court to effectively try to seek to mount a retrial of its own in a matter of this importance and of this complexity. Those are my submissions.
Thank you. Well, we've had some marvellous metaphors. We've had Humpty Dumpty, we've had Frankenstein, we've had Weed Killer, we've had Heath Robinson, and we'll have to go away and consider our judgments with all those metaphors in mind. I want to thank you all, counsel and solicitors and CMA, for the way this case has been handled. It's a very difficult case, and it's been handled very well, and we are in a good position, I think, to go away and consider our judgments. But that is thanks to your efforts. I know we've complained about the number of documents, and I know we've complained about the number of bundles and their numbering. But leaving all that aside, I think we're on top of it. We'll take time to consider our judgments. I'm not optimistic we'll get the judgments before the long vacation, but we'll do our best to be as speedy as possible. When you get the judgments, please deal with them in the usual way. Agree the orders to costs and any disposition. And if you want to have an argument, it'll be in writing. But as I say, we have been favoured with very expert submissions